Well, now it's everybody. Please take your seats. Please take your seats, and we're going to get started in just 1 minute. If we could close those doors at the back, too. We know we're going to have a lot of folks here, so I just want to let them get in and get seated. Hi, my name is Bill Saunders. I am the chairman of the Religious Liberty Practice Group, and I welcome you all to this session. Thank you for coming. I want to just say two things. Number one, if you're interested in these issues, please join our practice group and participate as much as you'd like. We'd love to have, many of you, this may be an issue you have been involved in. Please join us. The second thing is I just want to turn the program over to the judge, Andrew Oldham, from the Fifth Circuit Court of Appeals, who will introduce the panel and conduct the session. But again, thank you for coming.
Thank you very much, Bill. I am going to give just a brief introduction for our various panelists. In typical Federalist Society form, we have an all-star lineup to talk about a very important case today. The full bios for our illustrious panelists are in your handout materials, also on the app and on the website, so you can read more about them. But first is to my left and your right is Tom Berg. Professor Berg is a professor of law and public policy at the University of St. Thomas School of Law. He is the author of several case books, including perhaps the leading case book on today's topic, entitled Religion and the Constitution, which he published with Michael McConnell and John Garvey through Aspen Press. And he clerked for Judge Alvin Rubin on my court, the U.S. Court of Appeals for the Fifth Circuit. So thank you for joining us, Professor Berg. To his left is Professor Dale Carpenter. Professor Carpenter is the Judge William Hawley Atwell Chair of Constitutional Law at the SMU Dedman School of Law in Dallas. He filed an amicus brief, co-authored with Professor Eugene Volokh in support of the respondents in the Masterpiece Cakeshop case today, that we're going to discuss today. He's also authored numerous articles that bear on today's decision, as well as an award-winning book on the Lawrence versus Texas case. But perhaps his greatest achievement is clerking for my colleague, Judge Edith Jones. So thank you very much for joining us today, Professor Carpenter. To his left is Jerry Bradley. Professor Bradley is a professor of law at the University of Notre Dame, where he also co-directs with John Finnis the Natural Law Institute. He's written numerous articles that bear on today's discussion, including a book entitled Challenges to Religious Liberty in the 21st Century, published by the Cambridge University Press in 2012. He also participated in the Masterpiece Cakeshop case. He signed an amicus brief along with 33 other legal scholars in support of the petitioners. And then last but certainly not least, Louise Melling. Louise is the Deputy Legal Director for the ACLU and the Director of its Center for Liberty. She served as counsel for the Obergefell petitioners in the landmark 2015 decision of Obergefell versus Hodges, and she served as counsel for Charlie Craig and David Mullins, the two individuals who asked Jack Phillips to create a wedding cake in the Masterpiece Cakeshop case. So without further ado, I'm going to turn it over to Professor Berg, who's going to give a brief overview of the case and then his take on it.
Thank you, Judge Oldham. Jack Phillips, the owner of Masterpiece Cakeshop in suburban Denver, designs and creates custom wedding cakes and other baked goods. He declined a request for a wedding cake from a couple, Charlie Craig and David Mullins, on the ground that he does not design cakes to celebrate same-sex weddings because of his religious belief that marriage is only for one man and one woman. The Colorado Civil Rights Commission held Phillips liable for sexual orientation discrimination, ordering him to design same-sex wedding cakes if he designs wedding cakes at all. The state courts upheld the order, but the Supreme Court reversed 7 votes to 2. Well, Phillips had presented 2 First Amendment arguments. First, that penalizing him for his refusal to create the cake compelled him to express a message that he opposes, namely celebration of a same-sex marriage. And second, that it violated his right to the free exercise of religion. The Supreme Court ruled based on free exercise. The standard for the free exercise clause under the court's precedents is that the law in question must be, quote, neutral toward religion and generally applicable, end quote. The court held that the state, in applying its non-discrimination law, had acted not neutrally, but with hostility towards Phillips's religious beliefs and actions in two ways. The first aspect of hostility involves statements by two commissioners denigrating Phillips' beliefs in ways that the court held were improper for officials charged with adjudicating his case fairly. For example, one commissioner said that Phillips's acts were an example of, quote, using your religion to hurt others, which she called despicable piece of rhetoric, and analogized to religious defenses of slavery and the Holocaust. The second evidence of non-neutrality toward religion was that the state had earlier allowed 3 other bakers to refuse a fundamentalist Christian's requests for cakes with religious messages against same-sex relationships. The state had said that those refusals did not discriminate against the customer's religious belief, but that Phillips's refusal to create a cake celebrating a same-sex marriage discriminated against same-sex couples. So the court noted particularly that the state had reasoned inconsistently about the 2 sets of bakers. For example, one of 3 or so, 4 inconsistencies. The commission and courts had said that the wedding cake would reflect the customer's message, not Phillips, the baker's, but treated the anti-gay cake as reflecting the other baker's message, not the customer's, which the other bakers, could decline to send that message, so an inconsistency. All right, there's a very quick summary of the case and what the court held. Let me give my own very quick thoughts. I approach the conflicts between same-sex marriage and religious liberty from the perspective of having supported both rights in Supreme Court briefs and in articles. The court was correct to hold that same-sex couples should be able to live consistently with their identity by being civilly married. Jack Phillips likewise claimed the right to live consistently with his identity, his religious belief about the nature of marriage. The very arguments that underlie protection of same-sex marriage also support strong protection for religious liberty. Both same-sex partners and traditional religious believers seek to protect a fundamental component of their identity, including freedom to pursue conduct that flows from that identity, whether it's marrying a life partner or living according to God's principles. Both also claim the right to live their identities in public settings, not just in the closet, so to speak. Same-sex couples should have access to civil marriage and to goods and services in the marketplace. But religious believers likewise have a strong interest in living out their beliefs, not just in church, in the house of worship, in the closet, so to speak, but in their daily lives, in religious charities, and in their livelihoods. So many folks, perhaps some on this panel, think that one side in this struggle, same-sex couples or religious conservatives, must significantly prevail and restrict the other. That is a recipe for dangerous cultural conflict and resentment, and for human suffering either way. Religious freedom exemptions in the for-profit sphere do need to be limited and carefully defined, but Jack Phillips fit within a limited category. Small vendors forced to provide, in his case, expressive goods or services to endorse or celebrate an event, here a wedding, and in the vast majority of cases it's a wedding, to which they object, deeply object, and where other providers are readily available. So the Masterpiece opinion fits the project of protecting both sides, especially in its holding that states must protect religious objectors to gay marriage if they allow secular objections to anti-gay messages. Well, or could be religious objections to anti-gay messages too. I don't mean to label that only as a secular position by any means. This principle of consistency, of no double standards, is potentially powerful. Left-leaning states and cities will be unwilling to force socially liberal vendors to produce goods with conservative religious messages in violation of their conscience. Those states cannot then turn around and require religiously conservative vendors to produce goods with messages in violation of their conscience. But it's unclear whether courts will enforce this requirement of consistency seriously. 4 justices in Masterpiece signaled that they would not. Justice Kagan in concurrence, Justice Ginsburg dissent, each joined by another justice, argued that these 2 sets of bakers were actually different, even though the state hadn't reasoned correctly about them, Justice Kagan said. But they were different and could be distinguished if you reasoned it through correctly, because the protected bakers refused to make, this is mostly a quote from Justice Kagan, to make a cake, that is one with an anti-gay message, that they would not have made for any customer, while Phillips refused to sell same-sex couples a cake, a wedding cake, that he would have made for an opposite-sex couple. But that ignores that a custom-designed wedding cake has a message too. The content of that wedding cake might be explicit, even if it's symbolic, because symbolic content is protected speech as well, protected message as well. A rainbow design, for example, on a wedding cake. And that is a cake with a rainbow design that Jack Phillips would not sell to anybody. Now, his design process, he never got to the point of discussing that with the couple, Craig and Mullins, but his design process seems very likely to produce such symbolism, because he testified that his process involves learning his customers', quote, desires, their personalities, their personal preferences, so as to, quote, design the perfect creation for the specific couple, end quote. That process aims to present the marriage in an affirming light, which Phillips said he could not do here. Even without explicit symbols, a wedding cake still sends an affirming message. The cake says explicitly or implicitly, this marriage is to be celebrated, and in context, that is a same-sex marriage. Context matters to determining the cake's message. As Justice Alito observed in a hypothetical oral argument, if you have a cake that says November 9th, a great day, that cake means something very different when it's provided for a birthday party on that day versus provided for an anniversary celebration of Kristallnacht on November 9th. So it's a strong case that the custom-designed wedding cake is expressive. I don't believe that that opens the door to widespread denials of wedding services, for example, say by the tailor or the hairstylist or some of the other hypotheticals that were brought up at oral argument. Couples cut the wedding cake as a symbol of their union. There is nothing like that for tuxedos or hairdos. Making people look good is not a celebration of the marriage. Now we have another case coming up coming back to the court at some point, the Arlene's Flowers case about a florist, and we can talk about that in the, I'm sure, in the question and answers. Now, this discussion is about the cake's message, which sounds in Phillips's compelled speech claim, but the court decided based on free exercise. In fact, his free exercise claim overlapped with the free speech claim, because the other bakers were allowed to refuse cakes with messages, and so Phillips's claim for consistent treatment depended on showing that the custom wedding cake has a message too. And I think that will usually be the case in these situations where the claimant appeals to the treatment of other similar cases. Now, there are multiple other reasons besides whether the activity is expressive or not, why we're not going, I don't think we are going to have a lot of refusals that will present a constant case of indignity for gay and lesbian couples. Businesses have commercial incentives against turning away customers. In jurisdictions where non-discrimination laws exist, which is after all what we're talking about, because we're talking about exemptions from non-discrimination laws, in those jurisdictions, the dissenters from gay marriage are likely to be a minority in the first place. And they may also face boycotts and other pressures if they refuse. There are lots of other incentives to not refuse. And in those cases where refusal would cause material loss of access to goods or services because of a lack of alternative providers, I'd say there'd be a compelling interest. An exemption means that same-sex couples will very occasionally be referred elsewhere and feel insulted and demeaned. That harm is real. But it can't be considered in isolation. The baker forced to violate his faith suffers dignitary harm too. And materially, his harm is greater. If Craig and Mullins lose, I'm speaking in present tense, the case is still going on, they still get to live their lives by their own values. They will still celebrate their wedding, still love each other, still be married, and still have their occupations. If the baker loses, by contrast, he will not get to live his life by his own values. He will have to violate his conscience repeatedly, making wedding cakes for every same-sex couple who requests, or else abandon his occupation. Those permanent harms on the objector's side are greater than the short-term dignitary harm on the couple's side. And I'll stop there.
Thank you very much.
Religious liberty was planted in America by Protestants working on distinctly Protestant soil. The handiwork was nonetheless supple enough to absorb the shock of Roman Catholicism during the 19th century and to survive the death of the implicit Protestant establishment by the beginning of the 20th. By the end of World War II, American religious liberty had successfully incorporated Judaism into the new tri-faith America, thus the Judeo-Christian tradition. And by that time, American religion had balkanized into some 250 different sects, at least according to one Supreme Court justice. According to another justice, Robert Jackson, who observed in 1944 in U.S. versus Ballard, he observed that in this country, scores of sects flourish by teaching what to me are queer notions. Now, these sects included Jehovah's Witnesses, who characteristically believed in no human government. God's sovereignty over the universe is undivided. They refused to salute the flag, and they bitterly denounced Catholics. Yet the Witnesses won big religious liberty victories in the Supreme Court in cases where they did these things. Now, in the 1960s, American religious liberty digested religious individualism. What I mean is that existentialists who doubted God and other loners who professed no creed and belonged to no sect won Supreme Court victories too. And here I'm thinking of United States versus Seeger and Illinois versus Frazee. Now, each of these encounters left its mark. Religious liberty in America changed, but grew stronger and more inclusive as it encountered each of these new challenges. Even in the 20th century, as America experienced profound secularization, but the American institution of freedom of religion weathered that challenge too. But I think that identity politics, which suffused the same-sex wedding vendor cases, poses a grave threat to religious liberty. Indeed, for the first time in American history, it recently became respectable to publicly oppose religious liberty and its overarching value in our polity. Now, this unprecedented turn is ominous. It will not only, or is not only already diminishing our constitutional law, it will remap our common life. For religious liberty has always been a strategic linchpin of our political culture. Now, of course, Americans in the past often opposed particular claims of religious liberty. By Latter-day Saints concerning polygamy, by Catholics who resisted Protestant observances in the public schoolrooms, and by Native American parents claiming their rightful authority to direct the religious upbringing of their children. In past debates about the precise scope of religious liberty, though, no one publicly questioned the great and general value of religious liberty itself. But what's happening now is different. Opposition back then was to a specific activity of a particular religious group, say Mormon plural marriage. What's happening now is happening to religion across a broader front of issues. While the percentage of Americans who belong to some sort of religious body or church, or even say that they believe in God, are at all-time lows. And the brunt of this new hostility to religious liberty is not being borne by religious minorities either. Christians who adhere to what was until recently America's common morality are instead its chief victims. Besides, when Mormons and Catholics and Indians found themselves on the short end of the religious liberty stick, no one associated religious liberty itself with unjust discrimination or with demeaning anyone's dignity, much less did anybody associate religious liberty with hatred or bigotry. But now many people do. Now someone might be thinking that all this really means is that the sexual revolution is threatening religious liberty. And what's new about that? Well, think again. The Religious Freedom Restoration Act passed unanimously in the House and with just 3 dissenting votes in the Senate in 1993. I noticed the rebellion against sexual morality when I was in high school. How could any teenage boy not notice? And I discovered that college life was in full debauch mode when I enrolled at Cornell in 1972. No, the sexual revolution is part of the gale force headwind buffeting religious liberty. But sexual freedom itself is not nearly sufficient to threaten religious liberty. Only identity politics could do that. And here are 3 illustrations of what I mean. And I speak here not exactly of implications of the court's decision in Masterpiece, which decision was narrow and rooted in contingent facts. I speak rather of the way the wedding vendor cases, all of them really, are litigated, and how many of them, if not most of them, have been decided, again, based in and on identity politics. Okay, 3 illustrations of what I mean. 1, what believers invariably understand themselves to be doing, which is steering clear of their own immoral involvement in the bad conduct of other persons, is in these cases, at least as they're litigated, by forced reconceptualization replaced with a substitute, namely the personal status or identity of some putative victim, of some person self-identifying or presenting as a member of a supposedly vulnerable group. Thus, Jack Phillips' refusal to supply anyone, straight or gay, with a cake for celebrating what he regarded as an ersatz marriage is reconceptualized as discrimination against his gay customers. Innkeepers who refuse to rent to fornicators are charged with discriminating on grounds of marital status. Employers who cannot conscientiously distribute contraceptives discriminate against women. Well, you get the idea. Now, this override of the believer's self-understanding amounts to religious stereotyping. Indeed, a religious stereotyping which I used to think would not happen again in an American courtroom. Now, compounding this first error is the prevalent notion that where public authority recognizes or would recognize the religious liberty of, say, Jack Phillips, the state would be putting its own imprimatur on Phillips's unjust discrimination. And the thought even often is that the state would be putting an imprimatur not only on his discrimination, but even on the normative premise that Jack holds, namely that marriage between 2 men or 2 women is morally impossible. But it doesn't work that way, as I at least partly just suggested. Besides, no one ever suggested that when the Jehovah's Witnesses won the flag salute case, the Supreme Court was endorsing their denial of United States sovereignty in favor of God's undivided sovereignty. Lawmakers who recognize Amish claims about limited schooling do not thereby ratify old order Anabaptist beliefs. You do not profess, endorse, ratify, or show the slightest real sympathy with Native American beliefs by supporting their right of access to peyote-infused rituals. Now, this claim about a state imprimatur is, I think, jerry-rigged to make the facts of the wedding vendor cases fit an identity politics morality tale. Now, the third error, the third illustration, builds upon these first two mistakes. This one is often styled dignitarian harm. And the idea, as far as I can tell, seems to be that when one is refused a service due to the providers, to the service providers' moral qualms about what you're doing, your person or identity is demeaned and your dignity is attacked. Now, there are many mistakes in this way of thinking. One mistake is about dignity itself, which has to do with the inherent qualities of persons which make them rights bearers and worthy of respect. Dignity, properly understood, is not prone to be compromised by others' bad behavior toward you or even their bad opinion of you. But let's leave this mistake aside. In this context, what we're really talking about is perceived insult, about a same-sex couple's feeling that they have been humiliated or demeaned, even though no word has been spoken, no gesture made, that means anything more than it's against my conscience to participate in what you're doing. Then again, we are here securely in the realm of identity politics, where self-esteem, at least for those who happen to be in favor, rules. Now, of course, Obergefell trafficked promiscuously in this same identity politics, right? The opening sentence of that case introduces a liberty which includes, and here's the court speaking, which includes the right of persons within a lawful realm to define and express their identity. And surely the center of gravity in Obergefell is the idea that the law can and should express the community's affirmation of each person's intimate and self-defining choice of a companion, of that companion, to ward off what Justice Kennedy described as the universal fear that a lonely person call out only to find no one there. Now, no doubt the appeals of aggrieved sexual minorities are very powerful these days, but I think that even they could not threaten religious liberty if identity politics had not already infiltrated and hollowed out religious liberty itself. Before sexual identity could emerge as the colossus that it is in our political culture, religion had to be reduced from a set of beliefs and truth claims about the way the cosmos really is to nothing more than one singular expression of ineffable spiritual experiences and or the collective identity creed, the collective identity of one's religious tribe. Religion had to be redescribed over against the self-understanding of many, but far from all believers, as raw subjectivity, as a realm of faith, conceived itself as feeling and emotion, of faith as some inner domain of me outside the domain of rationality and of the objective order of things. Indeed, I submit that only after the public realm in America was secularized and religion privatized, and further, that religion in the private sphere be treated as just one of many possible sources of personal identity. Only then could American religious liberty be threatened by the rival claims of others to define themselves sexually, and to do so without having to endure the moral criticism of others, including believers.
Thank you, Professor Bradley. Ms. Mellon, thank you.
Thank you for having me. One of the things about going last is that some of my points have been made. So I'm not so much going to talk about doctrine. I think I really just want to pose sort of 5 questions for you or so as you think about the questions presented in Masterpiece and similar cases. And some of them may now just be obvious either because you came in knowing about it or because you've now sat through these other 4 panelists. So the first is just to put this in perspective, which is I think that these conversations are genuinely hard. And I think they're genuinely hard because when conversations arise about a conflict between religion or speech and LGBT people or women, the Hobby Lobby variety, it's because we're at a moment of change in society, and usually at a moment of profound change. The conversation around LGBT rights and the advances for LGBT rights, I sometimes refer to as like a tectonic plate shift in terms of where we've been, that we've had a long time, maybe forever, with societal norms looking one way, and then the norms looking another way. I think change is actually just incredibly hard, and people of faith are on both sides of those debates. People of faith have strong feelings of faith against, for example, serving a same-sex couple, and people of faith are supportive of laws to further same-sex couples. In that change, though, I just want to go a little bit to Dale's point about how big is the disruption in some sense, or how robust is the resistance, and note that there are the cases about public accommodations and resistance to serving LGBT people in wedding services because of faith. But it's not limited in that way to wedding services. There are also cases arising, for example, about a right to fire an employee because of somebody's faith. In that case, the employee was a transgender individual. To refuse health care, including in the LGBT context because of faith, as well as to refuse to place children who are up for adoption or foster placement with certain families because of faith objections. So the question isn't limited to the public accommodation sphere. So really, at the end of the day, I think there's just a question about whether we're going to accept into the law and the culture the LGBT rights in full form, and what the Constitution says about that. Remember that the claims in Masterpiece, we're not talking about a legislative debate, we're talking about a constitutional debate. The question is whether the Constitution protects the right of Jack Phillips in Masterpiece to say no, as in you don't go back to the legislature and keep having your debate in the legislature. It's a constitutional debate. Second, this has already been alluded to, this conversation, we're having a conversation about LGBT rights or sexual revolution, but this debate is in no way limited to the context of LGBT rights. I'm sure by now many of you, because you pay attention to these issues, have heard about the Piggy Park case. Piggy Park, the case of a barbecue franchise, South Carolina, soon after passage of the Civil Rights Act of 1964, refused to comply, and the owner talked about his faith, and his faith telling him that integration was contrary to his faith, so he wouldn't serve black customers in his restaurant. I think we know about Bob Jones University. Bob Jones University, the case in the Supreme Court, I believe, decided as late as, I know it was a long time ago, 1980, where Bob Jones was arguing, based on its faith, the right to refuse to admit students who believed in or advocated or practiced interracial dating. And there are a series of other cases. They don't go to the Supreme Court, but there are cases where women contest that they're paid less than men. And in those cases, those are religious schools, and the religious schools said, it's my faith that men should be head of households, and therefore that's my justification for this. In all of those cases, the courts said no to the question of a religious exemption. And so the question I just say would be, why should LGBT rights be different? Why should today's debates be different? And if you think they should be different, what is the rationale for the difference in that? I think, Tom's offered one version of a rationale for that. I think both Alliance Defending Freedom and the US Department of Justice in Masterpiece said they should be different. And I say, I think it's a struggle to articulate that. Third, Tom's touched on this a little bit, because Tom and I do this roadshow together with some regularity. And in terms of, Tom as well as Dale, we land in the same place sometimes, different places sometimes, I think it's fair to say. Maybe I land more with Dale than with Tom. But in terms of talking about equality, I think there are plenty of people who believe in LGBT rights in a real sense, as well as in the claims advanced by Jack Phillips. And I would just ask you to think about that and think about what equality means. You may make decisions about costs and where you want to land, but what does equality mean if after you sit down and Jack says to you, Dave and Charlie were there with Charlie's mother, for whom is this cake? And Dave and Charlie say, oh, like for us. And Jack says, I can't make that cake. So what does it feel like to be turned away in that context? Debbie, Charlie's mom, describes it. Debbie's mom talks about going out to the car after Jack has said no, and looking and she's in the back seat and she sees her son's shoulders shaking and he's crying, and he said, I feel like I'm just not good enough. We have to put that in the mix, as we also do have to put in the mix the cost to Jack Phillips and Masterpiece of what it means to be told that you must sell wedding cakes for all if you're going to sell wedding cakes, that you can't discriminate based on that. Fourth, I think in terms of the speech protections, I think there are, Tom is arguing that there can be limited claims for speech. Keep in mind, I think that the speech claim in Masterpiece was informed and infused by religion, but the speech claim is independent, I think, of religion when you really look at the claim. So, and there, the argument in the case, I think, really in many ways came down to an argument that this custom-made was different. Custom-made was art and custom-made was speech, and therefore different. And the Justice Department, I think, tried to narrow that further to say the speech claim was about custom-made for celebratory events. I'm not saying that that's expressive events. I was about to say, I know I don't have the exact word, but I have the concept. I respect that effort for people to try to figure out the narrow argument for this claim. I think it's a huge challenge, and I ask whether that claim, A, it's constitutional, so by that, in that sense, it's not narrow, but B, can it really be that narrow? I think if you look at and read the transcript of the oral argument, you'll see that the justices, I don't think they were just playing, I think they were struggling with what the parameters would be in that case. And I also think, when we look in other contexts, the conversation about being seen as participating is much broader than art. The conversation about, when I show up and I set up the chairs, I'm participating in the event, that, I think, for some people really is also a violation of conscience. And so how far does that go? Which brings me to my last point, which is about the argument that having exemptions will, what I say, sort of quiet the storm. That's the way that we could reduce conflict. And I think that argument often comes from a very good place in terms of a conflict. I know I'm a litigator, but not always fun. Very hard on society, and also an optimism that we can find a way to understand one another through that process. I have much less faith that that is in fact true, that granting exemptions will quiet the storm. I think there's a difference sometimes between legislative and constitutional exemptions, and I understand that the context I'm going to talk about is different, but if you look in the reproductive rights context, very, very soon after Roe, it's like more than 40 state legislatures all provided protections for doctors and institutions that did not want to participate in abortions. We all know that hasn't quieted the storm in any way. That hasn't quieted the storm in terms of a debate about abortion, as well as a debate about the reach of conscience claims, with the conscience claims, as we all know, running now to contraception, running not to providing contraception, but now providing insurance coverage for contraception, running to certifying that you don't want to provide insurance coverage for contraception, at least if you think that triggers contraceptive coverage, running also to referrals, running to information, and I think the instance that I find most surprising, I'll say, running to providing treatment for somebody following an abortion. I point that out. You don't have to, where you stand on the core question of what's right is different from the point I'm trying to make, which is that the exemption, the call for the exemptions has continued to expand in that context. And I think that is a very real possibility in the context of LGBT rights, or the rights in which we're continuing to have debate. So I think this is about LGBT rights, this is about speech, this is about religion, but at the end of the day, I think this goes really back to some core points that ran through. This is about how we think about anti-discrimination norms and how we think about anti-discrimination law.
Wonderful. Thank you very much to all our panelists. So we're going to have some Q&A in a minute. Before that, I'm going to ask our panelists to engage on a couple of questions with each other so they have a chance to respond to some of the points that have been made. But we will break right at 5 so that everybody can be prepared for the evening's activities. So why don't we start where, Louise, where you sort of ended, which is this concept of exemptions. So in the context of free exercise, the Supreme Court has set out a standard about neutral rules of general applicability in the Smith case, which I think Professor Carpenter had mentioned earlier. And in recent years, we have seen a couple of exemptions to the Smith test for neutral rules of general applicability. So a couple terms ago, there was the Hosanna-Tabor case that recognized a ministerial exemption to the employment laws, and then now we have Masterpiece Cakeshop. And it's, one of the things that's interesting in the Masterpiece Cakeshop case is that it's barely cited by the majority opinion. I think Professor Carpenter says that it's reaffirmed, but Justice Gorsuch writes a separate opinion joined by Justice Alito, pointing out that is, in his words, controversial amongst some of the justices in the context of the Masterpiece Cakeshop case. I'm wondering what you all think about the receptiveness of the Smith neutral rules of general applicability test and how it sits at 1 First Street.
Sure. One of the cert petitions now before the court, there are 2 cases that are similar to Masterpiece in their sort of basic facts, where there are cert petitions now pending before the Supreme Court. One comes out of Oregon, Sweet Cakes by Melissa, and if I am off on names of the cases, feel free to correct me. And then there's one out of Ohio involving a bed and breakfast. In one of those cases, squarely presents in the cert petition the question of whether Smith should be overruled. Mm-hmm. I will say I was actually surprised in Masterpiece that was not one of the cert questions.
And how do you think about where this doctrine stands today, in particular in the Supreme Court?
When Justice Alito was on the Third Circuit, he wrote 2 or 3 opinions that rested on the following proposition. When the government makes an exception for one secular interest that similarly undermines the state interest as a religious exception would, then the law is not neutral or generally applicable. The classic case of this is a Muslim police officer in Newark who wore a beard as a command of the Quran and violated a department rule that was just simply no beards. However, the department had made an exception for officers with a medical reason that was growing out of the condition that is especially common among African Americans, but some others have it too, where your skin is really sensitive and you need a beard really to protect your skin. So the department had made that exception. Judge Alito said that exception undermines the government's interest in uniformity the same way that a Muslim claim would. Therefore, the law is not generally applicable. It is not neutral toward religion because it treats a medical reason as more important than a religious reason. Whereas the Constitution says that a religious reason is really important. You have to treat the religious reason the same. Now, in that case, I think Judge Alito was trying to give as much protection for free exercise as he could within the Smith rule. And I've actually argued in favor of that rule. Doug Laycock and I, the approach of the Newark case, Doug Laycock and I filed a brief in Masterpiece arguing for it. I think it makes a lot of sense. But it also shows, I think, a lower court judge who's now on the court with a sense that maybe the Smith rule, taken in its broadest terms, is not real good for religious freedom. There was a different attitude towards this, I think, among conservatives in 1990 when Justice Scalia wrote the Smith case than there is now. I think there was more of a sense that judicial restraint, limits on what judges do to overrule majorities, that was a more central part of conservatism at the time. That's a much bigger topic, of course, of which many of you are interested in various areas. Now, conservatives tend to emphasize more the need to restrain government through constitutional norms, I think including the free exercise of religion. So what the court does with it, I don't know. Could they move in the direction of a Newark kind of rule without totally overruling Smith? I think that's possible. You know, they don't like to completely overrule a decision, but there are certainly ways to temper the Smith decision. And in fact, you know, you can read Laycock's and my scholarship. The Smith rule couldn't have been read as hard-nosed as it was thought to be in the first place, because it would be inconsistent with precedent before it. So, yeah, I think there's definitely the possibility that the court will temper Smith further.
Well, I don't think Smith will be overruled. I don't think it ought to be. I guess I'm a kind of duck that goes meow because I'm one of the very few people who's considered to be a religious conservative, or at least a friend of religious liberty, who's argued in print and in lectures that Smith was rightly decided, and I continue to think it was rightly decided. I don't think the court's going to tinker too much with that. I also would suggest, as a kind of going beyond Judge's question, I suppose, that the better way to think about the issues that we've been talking about during this symposium or this exchange really is probably better spoken about as an initial matter and mainly not in terms of exemptions from non-discrimination laws or anything else, but rather I think the best way to go about thinking about this is to just think that, one, a lawmaker, a generic lawmaker with care of the common good, and really part of that care involves taking everyone's interests seriously and respecting their rights. How does that person think all the way through to a statute or some provision of law concerning the wedding vendors and like cases? And I don't think that it helps to sort of start by thinking, well, here's the norm of justice that applies to the case, non-discrimination across the board, and there may be some exceptions to that. Rather, I would say that's not the way to think about it, but to think your way through to what the law should be once everyone's interests and rights are fully specified, and to think as respecting Jack Phillips' rights, for example, as part of that process. And I think if we do that, we can work then to the institutional questions and treat them as the secondary and derivative questions that they are.
I just have to note for the record that the ACLU, that here you have, you were happy with Smith, and we were opposed. We thought Smith was wrongly decided as providing too little protection for religious liberty.
Well, who'd have thunk it? Chuck Schumer introduced RFRA. Who'd have thunk it?
But I do think obviously taking account of everybody's interests produced the same kind of vibrant debate that we have now. That's true whether you call it exemptions, that's true whether you call it a constitutional right. We're just going to continue to have those vibrant debates. That was true in terms of, if you look back at the claims, for example, in Obergefell, in terms of several briefs being filed saying, even if the court were to recognize LGBT equality, that will be a threat to religious liberty. So people have deep commitments and deep faith on both sides, and so the discussion, that will be no more simple than this conversation about Masterpiece.
If we could back up a little bit to sort of how the court actually decided the Masterpiece Cakeshop case. It's something we talked about a little bit at the beginning. Professor Berg mentioned it, but I'm sort of curious if what your take on it is. You know, as Professor Berg mentioned, the court honed in on one set of comments by one of the members of the Colorado Civil Rights Commission. And then Justice Kennedy, in his majority opinion, says that the, quote, the record shows no objection to these comments from other commissioners, and later state court ruling reviewing the commission's decision does not mention those comments, much less express concern with them. And in the way that the Colorado Civil Rights Commission litigated the case in the Supreme Court, Justice Kennedy continues that they did not disavow those comments in their briefs filed in this court, that is the Supreme Court. So I'm curious what, if anything, we take away from Masterpiece Cakeshop in this treatment of those comments from the commissioner to infer discriminatory animus or intent of a multi-member body from the comments of one of, in this case, commissioners. We can start with Professor Berg.
Jurisprudentially, the conservatives on the court are not generally in favor of relying on statements of individual decision makers to show intent and strike down an otherwise valid action on that basis. That was one of Justice Scalia's bugbears, and I think others feel the same way. So what was it about Masterpiece that would make that different? The opinion points out that it's an adjudication. These commissioners were deciding the case as judges. You know, we don't want judges, we want to walk into court and have the first thing the judge says to you is, you know, I think your position in this case is one of the most despicable pieces of rhetoric I can think of. You know, even the appearance of bias by a judge is a problem. I think you could think of Masterpiece as, in a way, a case about the administrative state, because the same commissioners who prosecute civil rights actions, who bring in, you know, okay enforcement actions and are tasked with the job of enforcing it fully, are also the judges to decide the fair interpretation of the law. That's the kind of melding of functions that is common in the administrative state, and you know, whether this court will, what this court will do about that, and I know there are a bunch of other panels that were likely to talk about that, but I think you could read Masterpiece that way. You know, so in the Washington florist case called Arlene's Flowers, there are arguments about statements by the Attorney General of Washington, who made it a sort of mission to go after Barronelle Stutzman, the florist. And, you know, I don't just, so does Masterpiece, with its focus on the adjudication context, have the kind of traction to go beyond that? I don't know. It would, you know, it'd be a change in jurisprudence for conservative justices to go a long way with that.
Care to respond, anyone?
Well, I don't think it's clearly mistaken to do what the court did. I do think, as many people do, so this is not imaginative or creative on my part, I think the court kicked the can down the road because it didn't know what to do with the issue.
I totally agree.
Luis, nothing?
I completely agree with that. Completely
Well,
agree
I
with
see
that.
we have very healthy cues at both of the stand-up mics. So why don't we open it up to questions for the panelists from the audience? We'll alternate between the two mics, I just ask the panelists to try to keep your answers obviously responsive and powerful, but short so that everyone can ask their questions. Why don't you start on the side?
Hello, thank you for the panel. This question goes to Ms. Melling, but any of the panelists can feel free to weigh in. You mentioned in the wake of the Civil Rights Act of 1964, there were cases where there was an individual who, I guess, claimed that he was religiously compelled to discriminate on the basis of race, something to that effect. But I guess in that situation, you had really a conflict of rights. I mean, you had the First Amendment on the one hand protecting religion, but you also had the Civil Rights Act of 1866 and 1964, not to mention the 14th Amendment. So there was a conflict of rights there where the people spoke on both issues. Assuming the Cakeshop case had to do with discrimination on the basis of sexual orientation, which I don't accept, but assuming that's the case, where exactly are the rights of gays and lesbians protected anywhere?
So in Colorado, they're
Federally speaking, yes.
Oh, well, in Colorado, they're protected. Right, so that was the predicate. They're expressly protected under Colorado's civil rights statute. Federally, under the public accommodations law, there is no protection for sex, period, in the federal accommodations law. Well, we'll see, right? There are cases now up before the Supreme Court about whether the prohibitions on sex in employment law, in particular in employment law, reaches discrimination based on sexual orientation and gender identity. Several lower courts, Court of Appeals have held it does. The question's being teed up for the Supreme Court. There was there's a very interesting body of cases before 64, one even in the 50s, which are they're just surprising, where even the court talks about God wanting the races to be separate. Now, these are all very, very old, but they're surprising.
Okay.
Yeah, I mean, I think the Piggy Park case is just is a red herring. Nobody has made a claim or is arguing seriously a claim to refuse all service to gay people in sort of generalized commercial contexts, which is what the claim in Piggy Park was. However you put that, you could put that in terms of the breadth of that claim would activate a much compelling interest in access to goods and services as well as the basic dignity. You make a distinction between refusing a person overall and refusing, on the other hand, a particular form of conduct or particular religious norm based on agreement about the nature of marriage. I mean, to refuse to serve anyone in any context is, you know, what I don't know what Larry would say about this, it seems is more an attack on dignity. I think I'd agree with Jerry that that can't take away your dignity, but we don't really want to attacks on dignity. But different, it's just very different from anything that's been claimed in any of the wedding cases. And then, you know, the tougher question, I guess, is whether race and sexual orientation should be treated the same if you're talking about unnecessary cases, like refusing to make a cake for an interracial wedding versus a same-sex wedding. That's the real comparison. Piggy Park, I think, is a red herring. But you know, the way I look at it is not that sexual orientation is lower than all forms of discrimination. It's that this is the highest, higher than all the others. We have virtually no exemptions for discrimination in any law anywhere. We have exemptions for sex discrimination. Yes, some of those claims have lost. Sex discrimination have lost, Louise pointed out, but we also have exemptions for sex discrimination based on religious grounds. We have all sorts of exemptions for religious discrimination based on grounds. So it's, to me, the better argument is that race is constitutionally unique. It would take time to lay that all out, but I'll stop there.
Over here.
To what extent do you believe the holding of Masterpiece is limited by the facts of the case, namely discriminatory application by the Colorado Civil Rights Commission of the Colorado law? Would in another state that applies its anti-discrimination law evenly, a service provider be protected similarly to Mr. Phillips if he refused to provide service on religious grounds?
No, I think it depends. The holding is limited to its facts, and the facts could be replicated, but they would be replicated contingent facts. So I don't think there's anything that is medical or general legal protection generated from Masterpiece. I do think that matter entirely open, and people, including maybe people on this panel, although not myself, have to read the tea leaves as best they can as to what a majority probably would do on base question in a case that didn't involve these complex. And I think that's maybe worth doing, but highly speculative.
I think the Masterpiece that may wind up generating the most debate going forward is the discussion about William Mack versus Jack Phillips. And I think that was probably the point where that was where Dale was going.
Yeah.
But yeah, the big question just remains.
Please.
Right. I'm wondering if this hadn't been spoken about as a matter of discrimination versus discrimination. Well, we're going to have a rule against discrimination and then make exceptions, and I don't think that would be a positive regime. I'm concerned that there's not enough consideration of this, Smith notwithstanding, in the notion of neutrality as a question of discrimination against discrimination. It's simply all right to discriminate against people who are characterized as intolerant, as a class. And that's something that obviously the narrow facts and decisions wasn't addressed here, but I'm wondering as a kind of theoretical question if that doesn't concern the panel.
So I think there are two things to say. So as a matter of fact, the public discourse about this often is framed in terms of the dignity interests, both. I'll just say both sides, articulating the dignity of both sides, articulating the ways in which they feel subject to discrimination and culture, and who does and doesn't have a place in public society. So I think those frames exist. There are cases, certainly arising, early cases challenging contraceptive coverage rules, for example, where parties, I believe it was the Bishops' or Catholic Conference, argued that that the laws may have been discriminatory because they were passed with an eye toward who wasn't providing contraception or how they were enforced. And so that frame that I think you're suggesting has been argued in courts before, and I assume that that will continue to be argued.
I mean, part of the logic, actually, of the unequal enforcement was that that William Jack had brought who wanted the anti-gay cake, had brought a claim of religious discrimination when his request was refused, and the commission said that wasn't religious discrimination, but refusing the same-sex cake was sexual orientation discrimination. So one point here, I guess, is one of the things that the commission said was, let me summarize. I think one way to describe what happened in the commission in Masterpiece and in Colorado law and in general, I would say the progressive side of these, analyzing how progressive side analyzes these cases, is that they read sexual orientation discrimination broadly to encompass conduct that is inextricably tied to orientation, like relationship, like marriage, which I support that. But they read religious discrimination narrowly. In other words, it's not religious discrimination, not against just your affiliation. It's just because you're a Christian, just because you're a Muslim. If it's anything about your conduct, then that's totally different from your religion, right? Because what? Because conduct and religion don't really together. I mean, I don't think it's consistent, right? I would. The burden of the gravamen of my argument is that in the parallels between these two situations are that conduct and an identity, in a good sense, I want to say, Jerry, not the awful sense of identity, are inextricably tied together, but they are tied together for the religious believer too, and that's the point.
I have things to say, but I'll hear from other questions. No, it's okay.
Sure.
This sort of builds off the question. So what does the anti-discrimination, favoring non-discrimination, what does that mean for the use of religious neutrality by the court in the future?
I'm not sure. Can you maybe pinpoint the question a little more?
All right. I won't take my time. Anyway, I guess just kind of like, how the court desires judges to be kind of neutral in deciding religious matters, not being like, yeah, we believe your beliefs, we don't believe your beliefs, they're sincere, not sincere, we want to be neutral, that kind of role.
I mean, this is only a part, and probably a small part of a fuller response, but I wouldn't that there's two senses of neutrality in play in almost any Supreme Court discussion of issues like this, and in almost any discussion like ours of these issues, namely the neutrality among religions and between and among the different religious sects and individual religious worldviews. That's one thing, but there's also the neutrality, so-called, between religion as such and what's often not always called non-religion, occasionally called irreligion. Now that latter, I think, is unfounded and ought to be ripped out of the constitutional law as soon as possible. But I think that a more cautious statement than that would be that the Supreme Court, I think, is indicating its dissection with that broader neutrality, religion and non-religion. It's not really a doctrine or actually say it's rejecting this larger neutrality between religion and non-religion. But if you look at the cases, including Hosanna Tabor, Galloway in Greece, Trinity Lutheran, the court's decisions, the results in these cases are hard to square with this broader neutrality. And one thing that's telling is that the court in Hosanna Tabor, speaking of the Chief Justice, took up an argument made by the EEOC, I think here during the Obama administration, I think representing the administration's views. But the EEOC argued in that case that Lutheran Church in that case, Lutheran Church School, had rights. It had rights over personnel, but they just didn't have any rights over personnel as a church. They had the same rights as any other expressive group, Boy Scouts or Republican Party, for example. And what's telling about it is, so this was a view that was truly religion neutral, that there was nothing special about the religious character of this expressive association. It's just an expressive association. And the court dismissed that, simply saying, well, there is a free exercise clause, you know, and religion is singled out for a special positive treatment institution. That's just one example of many. I think the court continues to stand by this broad neutrality as a matter of doctrine. It will cite it in a case at the appropriate early moment, but it's not behaving bound by it.
Thank you. Mr. Mitchell.
I wonder if the panelists could comment on the Religious Freedom Act, both at the federal and state level, and the way it applies to the dignitary and stigmatic harms inflicted on same-sex couples who are told, sorry, I'm not going to bake a cake for your wedding. And specifically, I think most people on the left would agree that there's a compelling governmental interest in preventing these dignitary and stigmatic injuries that occur when wedding vendors turn aside same-sex couples. If that's true, I can think of things that are far more stigmatizing and demeaning to homosexual couples than that. For example, Fred Phelps and the Westboro Baptist Church, when they show up at funerals with the signs, we know what the signs say, pastors who preach from the pulpit that homosexual behavior is a sin, that homosexuals are going to hell if they don't repent. If there's a compelling governmental interest in stopping Jack Phillips from inflicting these dignitary harms on his customers, doesn't it logically follow that there's a compelling governmental interest in censoring the sermons of pastors who denounce homosexual behavior from the pulpit, or censoring the behavior of Phelps? Or is there anything we do?
So first of all, I think under the, and I think under RFRA, you see, at least when Kennedy was on the court, the same struggle between religious liberty claims and discrimination claims, as in Hobby Lobby. Well, he has his out in a sense, and I'm talking as if the court was all Kennedy, because in some ways it was in many cases, where he says we will certainly countenance the claim of Hobby Lobby. First of all, take seriously the assertion of the substantial burden, but we have a way both to recognize Hobby Lobby's harm and to continue to provide contraception, this is what they thought on that day, by saying that the government could instead have offered the accommodation to the for-profit businesses, the same process that was available to the religiously affiliated nonprofits. That was hotly contested, but still. And then in the case challenging the accommodation, that decision is sort of just like Masterpiece in the sense of the court saying, well, we have people of faith objecting to providing the coverage, and we have the potential harm if the coverage isn't provided, but I think we see some there might be an agreement, so go back down. So I don't know that we know yet. There was a RFRA claim that might have presented that question in the Harris Funeral Home case, where there's now a cert petition pending, but they didn't, the RFRA claim isn't asserted in that case. They dropped that one going up. When what's going on is speech, the First Amendment says that there cannot be a compelling interest in preventing the communicative impact of the speech, right? That's Fred Phelps, et cetera, yes. Where the harm comes through the message. It's different, maybe, in cases of conduct, right? So I think the progressive line drawn there is to say that Jack Phillips's action is conduct, not speech. That doesn't work even on its own terms, I think, if you see his conduct in making a cake as expressive. Because, right, the Supreme Court has a doctrine about expressive conduct, the flag burning cases. There, it's burning a flag, but it's communicating a message, and the courts twice struck down laws that were based solely on the communicative impact of expressive conduct. So if that's, if that's how you see Jack Phillips as expressive conduct, then I think, it's squarely within other cases. But
we are talking about the line between speech and conduct. So I think his case is very strong. So I basically agree with your point. But that I think is the way it all kind of shakes out in terms of doctrine.
But I just want to say three things back to Tom. So first is what the law regulates is what you do when you make a product. So to my mind, that the focus on the case is almost like diverting your eye from what the law was intended, what the law targets. The law targets the fact that if you have a product, the question is whether you will sell it, whether you discriminate in the person to whom you sell it. The law is regulating that conduct first. Second, in some sense, every act of discrimination is expressive, that somebody is motivated by some expression to say no to somebody for some reason. Three, if we think about the case coming out of, I think it's Washington, lots of conduct is expressive, but that doesn't put it squarely in the free speech doctrine. So, I mean, I'm blanking on the name of the case, but the case where there was a tent city basically set up in DC to protest homelessness, that was expressive, but that was treated as expressive conduct, not expression, even though it had a robust message.
Over here, please.
Yes, for Ms. Melling. I was interested in what I take to be, in essence, kind of policy arguments. What kind of a world do we want to live in? Do we really want to have, a rule where the state can't come in and defend certain rights? But let me try to turn it around a little bit. The position that Colorado is taking is that it is necessary for Colorado to mediate between rights claims from two private parties that are at loggerheads with each other. And this is substantially different from a claim in which the state is asserting its own interest, right, or its own rights, that if the issue is about the rights of an individual against the state, then the worst thing that happens for the state is the state loses and has to make some accommodation. But if the state's argument is that it is mediating rights claims among individuals, then doesn't that put the state in the position of being able to hide behind somebody's rights claims using what may be at the time the most kind of popular or politically useful position in order to grow the power of the state? Shouldn't we be concerned about inviting the state into mediating these individual rights disputes? And shouldn't that be a reason to treat the state's arguments more suspiciously?
So, mega question. I think that depends on how, obviously it depends on how you think about the state, right? So I see anti-discrimination laws, obviously, to the extent they're passed by a majority, but about trying to tip a balance so as to protect a minority, and therefore see the state power as often necessary to make advances in different ways. I'm not sure I answered your question.
Well, there is something distinctive. You put your finger on something distinctive about many of the contemporary arguments about religious liberty and other persons' rights. At least typically in the past, the religious claimant, whether it was Jehovah's Witnesses or Christian Scientists or somebody else, was stacked up against the state itself insofar as they were seeking relief from some institutional regularity or rule keeping or a norm, like police officers must not have beards, but some men, maybe Muslim men, want to have a beard. So there's a way in which it wasn't pitting one person against another. Whether we describe it a clash of interests or a clash of rights at this point, I think doesn't matter. And that is new-ish in our situation. Although I think fundamentally it doesn't present a new sort of normative challenge, because I think always in questions involving the kinds of things we're talking about, the question is whether the resolution in mind is fair to everybody, fair to everyone. Not so much fair to the state, but safe insofar as the state is the political community. So even in institutional context, just for example, the question would be about, let's say a prisoner wants kosher food. You'd say, well, it's really between the prisoner and the chef in the kitchen at the prison. Well, yes and no. It is that, but it's also a matter of fairness to other people. Namely, is it fair for me claiming a religious reason to get the better food that everybody would want but aren't going to get because they're not asserting a religious reason. So I think actually at the bottom of almost all religious liberty disputes and questions is a matter of fairness between and among people, especially if you consider the fairness of favoring religious reasons for doing something as opposed to non-religious. So I think that there is this new surface feature, which is a challenge to our thinking, but I think fundamentally it remains the same question of fairness to everyone, which doesn't mean by any means the believer always wins. That's not true at all. But it is a matter of being fair to Jack Phillips as well as everybody else.
I think we have just time for Tom to respond, and then we'll have to break. So apologies to those who didn't get to ask questions. We'll try to be available after the panel. But Tom gets the last word.
Yeah, really quickly. I would not yoke and tie the effort for religious liberty to an effort to repeal the active welfare state or the intrusive state. That's a much bigger battle for conservatives to win. The good thing about accommodations is they make it possible to protect religious liberty, an important constitutional value, even as we go on and fight in other forums about whether we're going to have big government or small government overall. If religious conservatives have to overturn the New Deal in order to get religious liberty protected, that's not a good strategy.
And with that, we'll conclude. Please join me in thanking our panelists for their time.